Hello neighbor, I'm Robert Burns and welcome. I believe this is segment 8, it may be segment 9. I lose track. Let's go with 9 because I believe that's probably it. Of the Stanford victims versus OFI litigation. And this is a first for Sound Off because in the history of this blog, we have never done 2 features in one day. So we're making history, but I feel compelled to do so in order that everybody can be up to speed for tomorrow's big day when this will go to the jury. All right, the last witness for the defense, that being OFI, was a gentleman named Joseph Borg, B-O-R-G. And look, I'm just going to say this, as we would say down here, he is the real deal, all right? And so I'm going to give you a link for his retirement from being the director of the Alabama Securities Commission. And you'll see quite a bit on there because I want to focus in much more so of what he had to say. Now, he was an expert witness for the OFI. Mr. Price fought and fought and fought to try to limit his expert testimony, but there was no way you were going to stop this guy from being an expert witness. And if you look at that link for his retirement, you will know why. I will say very briefly that he was a 1976 graduate of Hofstra up in New York, and the reason I bring that out is for the New Orleans Saints fans. You will certainly know that arguably the best, one of the best, if not the best, wide receiver in the history of the Saints would be none other than number 12, Marques Colston. So prior to that, I don't think many of us had that much familiarity with that university, but when he came in, I believe it was a 7th round draft choice and literally set the world on fire, we took note of Hofstra University. I'm not going to go into all of his career because you can see that on the link because I want to focus much more on what he had to say, but I want to make sure everybody knows that this guy is the real deal. All right. I'm just going to stress some key points that I deem to be by far the most important because I understand that talking about 506D, you know, and private placement securities is highly, highly specialized. I do remember them testing that on the CPA exam when I took it in 1989, but as he explained it, there was kind of an overhaul of it in 1996. But the bottom line is, if you are marketing to sophisticated, now everybody knows we have the secondary exchange, New York Stock Exchange, NASDAQ, and so forth and so on. And you can do an IPO, initial public offering, and that requires considerable scrutiny because that's available to the general public. On the other hand, these 506D, I believe it's D, offerings are what's called private placement, okay? For those, you need to have sophisticated investors. Same thing as accredited investors. We've covered that ad nauseum, and it's been covered in that courtroom far more than I've covered it here. But very briefly, $1 million net worth, net of your home, $200,000 income if you're an individual, $300,000 if you're married, and the ability to show that income for the next year. With that being the case, you can do these private placements, and the Stanford SIBCDs were falling under that category, the Reg D category for the private placement. And here's the biggest thing I want to emphasize of what he said, and he said it over and over and over again. State regulators cannot preempt federal authorities when it comes to these type securities. They are regulated by the SEC, all right? Basically, all the state gets is a notice. Once they have been approved, the state will get a mere notice that, hey, we'll be selling these securities in your state, and you'll get, from what I'm told, a small fee accompanying that notification for the privilege of selling those securities in your state. So that was the nature of these securities. And he went over I want to stress it again. He said that the state cannot preempt federal regulators on this, and by that he meant they shouldn't be seeking financials. Got to go through the feds for that. So he basically explained it, I believe at one point, as having your hands tied behind your back. He made it, as far as enforcement, he said it's kind of like seeing somebody going into a forest with a can of gasoline. You can't do anything about it, but of course, once the forest fire is on fire, then you can come in to take care of putting it out. They have no right to preempt. They cannot block that, because, you know, that's an important point of what the plaintiffs are trying to prove, is that, well, I should have gone in and blocked this. Like I said, after the 15 days, you get a simple notice along with that check. He said the gatekeeper role has been eliminated since 1996. That's when they had the overhaul of the private placement. Only certain people are accredited investors. We just talked about that. $1 million net worth and either $200,000 income if you're single, $300,000 if you're married. Now, Mr. Price has repeatedly said that, well, these investors were not sophisticated. And we'll get to in a second the very fact that Mr. Borg has been the only one that has succeeded in frustrating the living daylights out of Phil Price, but he managed to do so. But he basically said, Mr. Price, all I can tell you is I didn't make the law. This is what the law is. If you meet these categories, you are deemed to be an accredited investor that has the knowledge of these sorts of things. There's no need to blame him. He didn't make the law. It is what it is. And as far as Mr. Price's statement that, well, they did not have that level of sophistication, I want to again reiterate that Miss Allen, that was the boots on the ground examiner for Stanford Trust, she testified that the documentation was in place and signed by all of these folk, indicating that they were accredited investors. And it goes back to be careful of what you sign, because that's the end of her obligation, is to make sure that they had complied with attesting that these folks met the criteria of being accredited investors. So he talked about, I'm not going to spend much time on this, but he talked about distinguishing broker-dealers versus a financial advisor. In a broker-dealer situation, the obligation is to make sure that the investments are suitable for your client. There's a far higher level if you're a financial advisor. He said then you have an obligation to act in the client's best interest. It's basically a fiduciary duty. You act in the best interest with no conflict. Now, on direct, he was asked about his contract with the state. Now, he has been in attendance throughout the entirety of the trial. He volunteered that he is being compensated at a rate of $400 an hour, and that he had approximated that his billings up to the point of the trial, excuse me, would have been around, I think 45,000, 40 to 45, and then during the trial, we can expect another, I believe, approximately, well, he put, it would be between 100 and 140 hours I wrote down, so, you know, we can do the math. The total it's once everything is said and done, I guess it's going to be somewhere between, it's a little late in the day for me to try to do this, but approximately $100,000, give or take. And if I'm off on that, you know, all this was him being quizzed on how much he was being paid. I'm sure that if Mr. Valentino, Mr. Michael Valentino, who is the one that conducted direct on Mr. Borg, had not brought that out, Mr. Price certainly would have. He said that the Stanford situation, as he understood it, had 130 companies, and it was basically a, quote, mismatch, unquote. But he said the hierarchy of the regulations on this would be the SEC first, then FINRA, then the state. And he said, again, all these times I wrote it down because that's how many times he drove it home. The state has no right to preempt the feds. They are blocked from doing so. Let's see. There's a distinction he made that if the manager's collective portfolio is less than 25 million. Apparently, no, I'm sorry, if it's 25 million or above, that's going to be the SEC and not the state. And the state has no gatekeeper role for these private placement securities. However, he did state that the state regulators do retain the authority to investigate fraud if they can clear the hurdle of, having the requisite evidence that fraud is indeed taking place. Now, I've reached the point of where his testimony resumed today, and a lot of Mr. Valentino's opening was kind of hitting a review from the previous day, because you got to realize it was very late in the day on Wednesday when he was testifying. So I think that was a smart idea to refresh the jury's recollection of everything that he had said, but there's no need. I wrote it down, but I'm not going to repeat all that. He did say that, look, if you're going to substantiate fraud, this is very important. You have to demonstrate that there was an advance plan, basically to an advance proof of a Ponzi scheme, and that there's got to be an intent to deceive, an intent to harm or to steal someone else's property, in this case money. But he said you've got to have that as the foundation prior to launching an investigation. So in other words, he was saying you needed to have probable cause. Let's see. Let me see if I've gotten to cross or not. No, we're still on direct, but the three things that have been kind of highlighted that might have served to perhaps cause some concern was, number one, the fact that initially Stanford Trust was undercapitalized, but he explained that away that, well, any early business is going to be undercapitalized. He said Apple Computer, the very one now that the market cap is through the roof on. I mean, I don't know, it's 1.2 trillion. It's in competition with a couple of other stocks for who's got the most market cap, but it is an enormous amount of money. But he pointed out how at one point Apple was undercapitalized, because it was three guys starting this business in their garage, and look what it is today. So he said being undercapitalized in the early years would not serve as a basis for believing that fraud may be going on. The second item would be the concentration of the SIB, the Stanford International Bank CDs. He said that would not in and of itself cause a flag of fraud. He said it may be a bad business decision. He even used an example of Beanie Babies being sold when Beanie Babies were all the rage. I'm not even familiar with that, but I saw a couple of jurors that were. And he said, what happens when the fad of Beanie Babies wears? Oh, well, you got a problem, don't you, if that's 100% of your sales. The third element was the proliferation of those fees and whether or not they were prohibited by the tax code. He had said, look, I am not an IRS. I'm not a tax lawyer, so that's really beyond my scope. And I wrote down, let me see. Let me skip that because I don't want to state something wrong. Y'all forgive me, occasionally my handwriting, I guess I start to get a little more relaxed as it's getting close to lunch. But at any rate, he again reiterated that fraud, there's got to be an advanced plan to steal. It's not enough to investigate fraud absent the probable cause. He said that over the course, excuse me, over the course of his career, Ponzi schemes had existed in Rotary clubs and churches. And he said in his review of the documents of this case, the SEC on, it looks like 4 occasions, probably had potentially the sufficient evidence to perhaps trigger a more formal investigation. He said they basically dropped the ball, but they're the ones that would need to do this, not the OFI. And he stressed over and over again that states can't go out there making treaties with foreign countries. That's the area of the feds that, you know, that, I mean, they just cannot do it. They would be violating U.S. law to do so. He said also OFI had no authority to determine in self-directed IRAs what would be a suitable investment. Let's see. That would be the broker's responsibility, and I already talked about the fact that if it rises to the level of a financial advisor, they're they're going to have an even much higher burden because it's a fiduciary relationship. You have to act in the best interest of the client with no conflict. He was asked for a hierarchy of who should be blamed for all this. Obviously, the perpetrators would fall number 1. He said second on the list would be the brokers and our financial advisors that may be involved. Third was the Antigua regulators. We already talked about them last video, you know, the bribes, the whole 9 yards. Then the auditors that I believe was CSO, Howlett, something like that. And then to a lesser extent, he mentioned 2 law firms. I think I mentioned in the last video, Bazille, Saxe, and Adams and Rees having been sued, but he said he didn't know enough about to assign specific blame to them. He was specifically asked, did the OFI, were they in any way negligent from everything you looked over? And he said no. He again emphasized that when a state gets told that, hey, these securities are going to be sold in your state, you're going to get that little slip, and you can't do anything about it. Nothing. That's all left up to the feds. The OFI had no authority to try to preempt the feds on this matter. Again, on the self-directed IRAs, he said it would be inappropriate, same thing Miss Allen testified to, would be inappropriate for OFI to reach out to these investors and try to tell them what you can and can't invest in. He did indicate that at least the Texas state regulators would have been in a better position than Louisiana ones to try on anything, with regard to Stanford Trust. Mr. Price then began on cross-examination, and as I said, Mr. Borg is the only one who's managed to get under Mr. Price's skin. Now, Mr. Price kind of started out making a few jokes about SEC, and he said, to a large degree, you're just doing Monday morning quarterbacking. Is that not true? And he said, no, I don't agree with that. It's not Monday morning quarterbacking. Let's see. This is when things started to get out of hand. Mr. Price at one point was wanting Mr. Borg, as a result of a court case that Mr. Price had put in front of him, and it was the federal court that rejected this and said, if you're going to litigate this, it has to be in state court. And he put a U.S. Supreme Court case in front of Mr. Borg and had him go to well, first he had him look over it because Mr. Borg said he didn't have familiarity with it, so it took several minutes to look over it, and he said, now look, does that U.S. Supreme Court case not say that SIBCDs are not covered? And Mr. Borg said, no, I cannot agree with that statement. And he said what it basically says is that they are not going to be considered covered securities for purposes of this litigation only. Clearly, they must have been considered covered when they were issued, or they couldn't have been issued. But at any rate, when Mr. Price asked a question after that, Mr. Borg turned and posed a question, and Mr. Price got livid and said, I'm asking the questions here, and it was heated. And when things calmed down just a tad, Mr. Price asked Judge Johnson, Your Honor, what is your pleasure? And Judge Johnson said, my pleasure is for the temperature to be turned down, and he did not mean the thermostat. So Mr. Borg apologized to the court, although my observation is most of the elevation and anger, which Mr. Valentino said was, quote, badgering the witness. The two of them did manage to smile at each other and lower the tone quite a bit. Because that was an interesting, I wish we could take cameras into the courtroom. I'd love to be able to show video of that. But he emphasized that that you were really going to have to rly upon the DOJ, the FBI for enforcement of this, and states can't run around and just start doing treaties with foreign countries. They just flat cannot do it. He was then submitted to redirect, and Mr. Valentino only posed a couple of questions, and he said, did he see any need for a cease and desist to be issued to the Stanford Trust anytime prior to 2008? His response was no. He was asked, in all of the documents you reviewed, did you see anywhere where OFI did anything wrong? And his response was no. Now that's going to conclude the testimony, and that was the last witness, and so the OFI rested. Now, I had said yesterday that there were going to be some chess moves, and that's what transpired. Let me just bring you up to speed on where we're at and where it looks like, well, not where it looks like, where we are going. Mr. Price intends to, actually has said they were going to go down to the clerk of court's office like that, which was, I don't know, about 3:30, give or take, and file a motion for, excuse me, for directed verdict. We're talking about this whole comparative fault issue. And during a wait time from the jury, that all got hashed out ad nauseum, and I'm not going to go into it, but at any rate, Mr. Price was going to be filing a motion for directed verdict with regard to the whole comparative fault issue. The opposing counsel was to be provided with a copy, and Judge Johnson asked them when they could have a reply brief. Mr. Blunt said, Your Honor, we can have that in no later than 8:30 tomorrow morning. And so Judge Johnson said, okay, look, I'm going to read the motion today because it was already briefed. I'm going to read the brief today. I will read the reply, the response tomorrow morning. And he said, now I want both of you to know I am not going to have y'all up here spending a ton of time arguing this. He said, you'll get a couple of minutes and then we're moving on. that he would make his ruling, and that would be that. So after that, and there's some massaging of the jury instructions that presumably they were, well, not presumably, they were going to be working on after I left, which means they're probably working on them even as we speak. So here's the way things will go down. Officially, court will reconvene at 8 o'clock tomorrow morning. Now, the jury's not going to be present for this directed verdict. So they may have to hang tight for a little while, something they've gotten very used to doing. And by the way, Judge Johnson, when he dismissed him, he indicated that, look, I realize that the frustration level's probably pretty high, but he said, please just be trustful that we're going through a process that makes our system as great as it is. And so while it may seem like very frustration to you, please be understanding of we're trying to do things the right way and the proper way. And I thought that was good to try to assuage what I think common sense would dictate that these jurors probably had quite a bit of frustration through this. So, so what will happen is there'll be the motion for directed verdict away from the jury. Judge Johnson will make his ruling. Once the jury instructions are finalized, the jury will be brought back in. Closing arguments will begin. I'm gonna speculate a little that probably will commence at around 11 o'clock, 11 a.m. Speculation on my part, don't hold me to it, but I've gotten a decent gauge of how things move in this, and I'm gonna throw that out as my best guess of when closing arguments will commence. Then there will likely be a break for lunch. Then Judge Johnson will read the jury instructions. He's already indicated that will take approximately 1 hour. So my best guess, and it is a guess, but I think it's an educated one, is that the jury will be provided with this case sometime around 2:30, 3 o'clock tomorrow. And then it will be all in their hands. And I will say this, there were about 35, maybe even 40 audience members today. So folk know that this trial is coming to an end, and so the victims packed, well, it didn't pack the place, there were some empty seats, but we're talking about dramatically increased attendance from what has been the case. Some days there's been as few as 3 people there. Channel 9 was there, Jerry Rosado was there, so obviously the big time media is getting ready to break the story once the jury has reached its decision. So if you wanted to know what all happened leading up to it, I guess Sound Off was your only source. We've been happy to do it. This is a case that had strong interest for me, even though I know John Q. Public, it probably doesn't hold a whole lot of interest. But we're about to cross the finish line. So for those of you who have chosen to tune in to all of the episodes, thank you for your diligence. I realize that sometimes I've said things that weren't pleasing to hear for some of the audience. It is what it is. Everybody knows my thoughts on this case. They have not changed. But it doesn't matter what I think, or what my belief is, or what my vote would be if I was on the jury. What matters is those 12 members, out of the 13, we only have 1 to spare now. It's what they conclude that really matters. And we will certainly let you know what their decision is. Well, you're gonna see it in the mainstream media, so I may just largely just issue a quick little thing and just give the mainstream media's in any interviews they're able to do. And that will then conclude this. So it's been a very grinding ordeal, but I do like these sorts of cases. I much prefer civil cases than criminal. So thank you so much, and we will see you once again, probably with, well, not probably, it will be, with whatever the final verdict is. Yeah, I think these were 9 episodes. For those of you who tuned into 9 of them, or even any amount thereof, thank you so much, and we'll see you again real soon.